Good afternoon.
Hi, Professor. How are you doing? Good morning.
I see you. It's time, and we are now live. We are live, and we could proceed with the session. Over to you, Dr. Marota.
Good day, Professor Milton.
Great. How is it wherever you are? Proceed, sir. Good afternoon.
Hi, Professor. How are you doing? Good morning.
I see you.
Hello, everyone. Today we are going to start the session related to chemical, biological warfare, and international criminal court. Today we are going to have the presence of Professor Dawarkanath Shripati. He's a professor of international criminal law of the Singularity University in India. We are going to have the companion of Professor Frimpong. He's the founding law dean of Gimpa University and the founding law dean of UPSA Universities. Also is going to join us Professor Rama Dugudumela. She's a professor of international criminal law in India. At the same time, Maria Mercedes Pisani and Alessandra Lanciotti from Italy, from the University of Padua. Also, Dr. Itaba Ranzane, he's the Director of Government and Legal Services from the Government of South Africa. At the same time, Madacela Leso, he's the Director of the Government International Relation of the Department of Justice. Also, a researcher, Brian Ramafane. He's a researcher at the Center of International Criminal Justice. And finally, we have the presence of Manrit Kaur. She's an attorney at the ICC. And Brenda Okot, she's a specially expert international attorney from Sweden. Okay, Professor, I pass it to Professor Milton.
Thank you, Doc. Thank you for that erudite introduction. Dr. Giovanni Marotta is the Director of International Programs at the Center for International Criminal Justice, Africa. He is concerned with mobilizing all the programs and content and internal issues connected to of an international character for the center. He does a very good job, and we are pleased and we are proud to have you here. We'll be soon joined by a number of professors. This is a professorial board, panel which discusses issues, as Dr. Marotta has just indicated. And the topic is a very, very hot topic, chemical and biological weapons. There's also the nuclear weapons, which we are going to look into as to whether those can be enforced by the International Criminal Court. Of course, this is a debate that has been raging on for a long time, and we still want to perpetuate this debate, but give it more flesh. We reinforce the aspects that have been contentious with respect to this particular debate. Okay, as we wait for our colleagues to join us, we just want to announce one or two things which are in connection with our programs at the center and in terms of our broadcasts. One, we're going to strictly stick to 1 hour, 30 minutes maximum for these programs. I think Dr. Marotta will be handling that. I just want to announce that so that we are able to accomplish what we do within that time, so that we don't extend more than that. We have people who have other engagements, and we also want to reorganize our program so that the other contents can come in good time. The other issue is that we'll be reducing the number of schedules. We'll not be having this on a weekly basis. We'll be having our programs twice in a month. This is the reason for this particularly is to allow us to be able to adjust and put in other contents. We are developing other contents which we'll be broadcasting within the center. And those ones include, we'll be featuring interviews with personalities within the international criminal justice cycles. We'll be dealing, therefore, with the people at the ICC who will be featured more often. We'll also deal with politicians, heads of governments and states. We could feature individual of them, some of them online, and address issues which are pertinent. We are also going to allow news analysis for matters which are very pertinent, which are contemporary. Apart from that, we'll also include countries. We could feature a particular country and give the context of what is happening. For instance, Afghanistan. We could try and feature, and so those are the kind of content and others which we'll be able to bring forth in due course. So this will allow us at the center to mobilize ourselves, and we'll also welcome the panelists who would want to join us on those particular programs, and those who have features who would want to have them featured would also be part of that arrangement. But most of those programs will be run by myself and the Director of International Programs, Dr. Giovanni Marotta. Those are the key things that we might have to deal with. That's why we are restructuring the whole arrangement. We also need to give adequate, ample time for our panelists to prepare for, effective debate. That is why we'll be allowing that twice in a month. And probably it might go on to once in a month when the other programs become more crowding and more engaging. Okay. Apart from that, today, before we embark on the real debate, we want to feature, there's a current issue which we can probably discuss with Mr. Marotta, Dr. Marotta, rather. Dr. Marotta, thank you for the time that you've given me. Now, we recall in retrospect, we saw that the United States has slammed the ICC prosecutor and the head of jurisdiction complementarity at the International Criminal Court with visa, not just visa, in fact, there are sanctions, a wide range of sanctions that have been slammed upon these two individuals. And the indication that those who support them would be supporting them, would be able to face the same wrath. This was by the Secretary of State, Mr. Pompeo. What is your view on this, really? What is happening with the United States and the ICC?
Well, what I see here, yes, thank you, Professor. What I see here is that they are in some point trying to pressure the ICC, not in a political way, not to prosecute American citizens. I think it's like they are trying to shield probably I think the issue goes so far than any military rank in duties right now. I think it's more for protecting the contractors that have done in the past services for the government of the United States. If you see the context when the United States back then in like 18 years ago, the 18 years ago after, more 19 years ago, it's going to be after 9/11, the invasion to the first military engagement in Afghanistan, and then going to Iraq in 2003. Iraq is going to be 17 years, and the military intervention in Afghanistan is going to be 19 or 18 years. The first there was a lot of money expenses related to the military issue. Then after the Congress administration back then, they decided to cut money to the military, and that's why they decided to use the contractors, and at the same time they thought that using contractors will shield them not to be prosecuted against war crimes or any that kind of felonies. For example, in a court in that claims universal jurisdiction or in an international court. However, over these past 20 years in global as a whole, related to the contractor business, uh, the private sector, the private military sector, uh, if you see, and probably we as the ICC Justice Africa, we can do a research related on that, because I don't know if right now it exists, a kind of research, is how much money the private military sector, the contractors, um, especially in the United States, have give money for both campaigns, Republican or Democrats. So I mean that's the lobby they have been doing there. So I think that this move of Trump trying to ban and trying to block the not the judges, more the prosecutors. It's more like trying to wave a white flag to the contractors, telling them, okay, if you support me in now November, you probably will have 4 more years of impunity if you do something that was in our interest overseas, and you committed some by negligence some kind of international crime. I mean, there is no one who's going to trial you in any part of the world. So I think the goes that way. And on the other hand, we are right now entering in another Cold War between the US and Russia. It started with the pandemic.
Yeah.
We just saw that when Vladimir Putin told the world that they have discovered the vaccine. It was not the race who put the first man on the moon. It was who controls this new medical case of the pandemic trying. So, for example, they will start. I mean, there are countries in South America that in Latin America that will start using the Russian vaccines, and because of that, Oxford, that, well, you know, Great Britain also is the big brother of the U.S. They are trying to enter to other Latin American countries. So
Yeah.
we see once again another scenario for a Cold War. So probably we will enter into an, as I have made this example before, the way we will see war between countries, between continents, is going to be very, very different. Probably we will engage in another third world war, but it's not going to be the same scenario that was in World War II or World War One. I mean, it's going to be different. It's going to be more related to economics. It's going to be more related to medicine. It's going to be more related to espionage and cyber attacks and I don't know, biological. It's going to be like the use. It's going to be more like the way the war of Vietnam. It's going to be more like um, a guerrilla war. Nonetheless, globally. So I think that's the reason why the U.S. is trying to tell the international community that even though there is an ICC that is going to try war crimes, they are going to be over that, so they can protect themselves against these kind of possible scenarios. But I mean that's a little bit it's more defending the interests of a private sector that they are seeing from right now, I don't know, 30, 40, 50 years, the profit of the market that they will engage in the coming years. I mean, if we enter in another scenario of Cold War mixed up with guerrilla warfare in every different part of the world, I mean, that is the perfect storm market for the private contractors' military services. So they are trying to protect they're trying to protect that future market. The audience need to understand that the U.S., the American, they in all the places is going in any part they will see a profit business. So that's the way they think. I mean, you know, it happens in every level of how the U.S. Engage between them. They always see we can what under these circumstances how we can make money. So that's what I think is going on behind this Pompeo's
Pompeo.
yeah, this Pompeo thing about trying yes, trying to ban the prosecutors of the ICC is more. I mean, there are interests behind him related
Yes.
to contractors. So I mean, they're trying to protect the way they are we need to understand that the military private sector, they have this view as militaries. I mean, they always are 2 or 3 steps behind what's going really on politics all around the world, even in the US and every other country. So they make all these projections and statistics of how the market will wave by and they try to make some profit about that. So yes, I mean right now the business is going to be medicines related to all of this pandemic, and local military conflicts, and there's money. So they will try many countries. They will not send normal troops because of the COVID-19 situation. So they will hire these contractors to move to some places. So they see they are
very insightful indeed, Dr. Marotta. Very insightful.
And all the American, I mean, and the 80% of, or I'm going to, the 90% of the market of the private contractor services are American companies.
Yes.
And that's a way the U.S. is protecting that kind of market, so they want to have money from it. So, yes. So I think that's the real reason, more than trying to say that the U.S. is an autonomous country and they have this very remarkable, unbelievable justice system. It's more than that. I think they are trying to they are cooking the books. I mean, in all countries, there's going to be.
Okay, Dr. Marotta, I think time does not allow us to continue there, but I think we'll take it up from where you've stopped. It's quite an interesting discourse. Let's welcome now Professor Rakanath Tripathi. Can you hear us, Doctor, Professor?
Yes, sure. I can hear you.
As always, Prof.
And a very good evening to both of you all.
Good evening, Professor.
And the co-host.
Yeah. All right. We were just discussing the latest contemporary issue where the Americans have issued more warnings and imposed sanctions on the ICC prosecutor. You aware of that?
Yes.
Yes. So just 2 days ago, the news that Secretary of State was announcing that they have actually frozen the assets of 2 personalities at the International Criminal Court, namely the ICC prosecutor, Ms. Fatou Bensouda, and Mr. Chok. Sorry, I'll get the proper pronunciation. But the head of complementarity He also heads jurisdictional department, jurisdictional complementarity. All these have been targeted because they are still in the argument of the Secretary of State of the United States. They're still pursuing the American interests, the Americans. So they say even those who are aiding them, who are facilitating those that pursuit against the American citizens would also face the same fate. That is what briefly we're looking at, just as a contemporary. But we welcome you once more. Before we proceed, I would like to make an announcement that I just to keep you up to date with the announcement that I made at the beginning. The two important announcements are that we are restructuring our programs at the center. So we may end up having only 2 sessions in a month for the panel discourse for the professors, but there are other contents that we are coming up with, which will run to give us enough time. We'll be featuring personalities and institutions like the ICC. Will be holding certain discourse with these particular persons, in particular individuals or personalities at the ICC, heads of state and governments all over the world, not just Africa. And we'll also be featuring ministers of justice. We'll be featuring politicians, activists. So we are going to engage a number of personalities internationally. And in this particular program, it will be a one-on-one schedule. And you definitely will be there if you're interested. You'll pick which topics you're interested if you see any announcement. Some of them you could actually be handling those particular persons yourself if you have it's of interest to you. So these are the contents we want to generate with the center so that we don't just focus solely on the discourse. We also focus to hear from other people what they say, and we engage them in issues of international criminal justice. The other point that we raised was that we will stick to our initial program, which lasts 1 hour 90, the way we started, to allow for the professors to have sufficient time to attend to other things, because some people may not be able to make it, not because they don't want to, but the time factor does not allow them to engage into other things as well as this one. So we'll stick to 1 hour 30 minutes for those 2 sessions we'll have in a month. So the next session we'll be having on the 28th of September. We are left with 1 more session this month for the discourse panel for the professors. But in between, there are a lot of programs which we'll announce, and we'll be informing members if somebody is interested, they join to participate upon interest. We'll be featuring countries also, so we can feature Afghanistan and get there and see what we feature countries that have relevance to international criminal justice. The idea is to enlighten our viewers on what is going on. The other thing also will be discussing the contemporary issue, just like what we've been discussing with Dr. Marota just now. It's a very interesting one. Like any new development that takes place within the ICC, we take it up. It would take our time and we feature it, we discuss it, and we engage other persons. Those are the announcements we made, Professor, in your absence. And so today we are proceeding with the chemical and biological weapons, nuclear weapons, in connection with the Rome Statute, basically. When you talk about the ICC, I think the discourse will feature largely on what the Rome Statute provides. I believe most of this discourse will center around the provisions of Article 8, sub-article paragraph B, sub-articles 7, 8, as the other my panels, my professors will be able to bring out. So I hand you back to, that is what we had, Professor Sipathi, in your absence. And I hand you back over to the Director of International Programs, my co-host, Dr. Marota. Over to you, sir.
Okay, thank you. Well, thank you also, Professor Sipathi, to be with us. As before starting the conversation related to the prosecutor of the ICC, I need to remember that today panel is related to chemical, biological warfare, and the ICC. So as usual, I bring the question here is that among scholars, there is a discussion related to if the use of chemical or biological weapons in armed conflicts is a serious crime of international concern. However, it should be explicitly prohibited by the Rome Statute, because according to the statute, it refers not such as a chemical weapon. It only refers as, one moment please, here. It only refers as weapon of asphyxiation. So to the panel right now here, what do you think about this? Should be an amendment to the Rome Statute directly that it should be criminalized chemical and biological weapons, such as chemical and biological weapons, or it should keep as the text is in Article 8 of the Rome Statute?
May I?
Yes, Professor.
Thank you. The Rome Statute does not specifically mention chemical weapons by name, although a lot of efforts were made by the state parties at the time of the signing of the Rome Statute in 1998 to include even the use of chemical weapons as a part of war crimes. But somehow some of the states were not ready to accept it, and therefore the chemical weapons were not included in the Rome Statute initially in 1998. But during the Kampala amendments, states have managed to include certain kinds of chemical weapons, and the most relevant article of the Rome Statute in this regard is Article 8, Clause 2, Clause P of the Rome Statute, which deals with war crimes. And this section of the Rome Statute, which deals with war crimes, includes certain provisions which may be interpreted and understood as applying to chemical weapons. The word chemical weapon is not used, but the provisions are there which can be interpreted and understood as referring to chemical weapons. Now, Article 8, Clause 2, Clause P, 17th para, makes it a war crime to employ poisoned weapons, and para 18 refers to employing asphyxiating, poisonous or other gases, and all analogous liquids, materials, and methods of warfare. So here the word chemical weapon is missing, but the words used are poison and poisoned weapons. So poison also amounts to a chemical. It's a chemical which acts on the nervous system of an individual. So in a broad sense, if we consider this word poison or poisoned weapons, it does relate to chemical weapons. Now again, para 18 also refers to employing asphyxiating, poisonous or other gases. Now gases are again chemicals. They are no different. So although the word chemical is not used, these can be understood as being chemicals that are used in warfare. and all analogous liquids. Analogous is liquids which are similar to gases and which are poisonous in nature. Then materials and methods of warfare. So these two provisions of the Rome Statute, although do not use the word chemical weapons, do consist of these two provisions which speaks of chemical weapons. And we should at least interpret and understand it that way, that the Rome Statute includes chemical weapons. Now, para 20 of 8.2 clause 8, article 8, clause 2, clause B, para 20 clearly makes it a war crime to employ weapons, projectiles, and material and methods of warfare. So, projectiles with chemical warheads, because we have weapons, missiles with conventional warheads, missiles with nuclear warheads, and missiles with chemical warheads. So when we employ weapons and projectiles with chemical warheads and also materials and methods of warfare, it does amount to a kind of a chemical warfare, and the Rome Statute is, I feel, quite clear that it includes the chemical weapons, though the word chemical weapons is not used. Now, these chemicals, which are of a nature to cause superfluous injury or unnecessary suffering, because if we go through the laws of war under international humanitarian law, one of the objectives of international humanitarian law is to avoid unnecessary suffering on the part of the combatants. Now, if we have to kill a combatant, fire a bullet in him, he dies. But is there a need to use a chemical weapon that would make him suffer for hours together? He would not die immediately, but he would suffer a lot and then finally die. So this is unnecessary suffering, which the provisions of international humanitarian law clearly prohibit. And it is one of the objectives of international humanitarian law to limit unnecessary suffering. And states today at the time of war also use tracer bullets. Now, these tracer bullets are such bullets that when they enter the human body, they explode inside the human body. And all the small lead pieces get embedded in all the important organs like the heart, the liver, the lungs. They puncture the lungs. So the chance of survival is zero. In the case of a single bullet being fired, the soldier stands a chance to survive. But when a tracer bullet is fired, there is chances are zero. So is there a necessity to use such weapons in warfare? And on similar lines, chemical weapons are also such that when the chemical weapons are used on civilian population in a war, then chemical weapons are of such a nature that it has an effect on future generations. Children would be born with disabilities, deformities. So it is not a weapon that simply affects the present generation, but future generations. And therefore, in my opinion, it is a very, very serious crime and an international crime, rather war crime. And therefore, I sincerely feel that the ICC should consider this and then start investigations against any head of the state or country where such chemical weapons have been used. Now, the provision that is part of the Rome Statute, that is Article 8, Clause 2, Clause B, that is para 17 and 18. These provisions are subject to a comprehensive prohibition and are included in an annexure to the Rome Statute. Since no annexure to the provision was agreed to by the states, no one can be prosecuted under this provision. So there lies the difficulty of the International Criminal Court. The court should overcome this. And although the Rome Statute should be understood as also prohibiting chemical weapons, as I mentioned earlier, Article 8, Clause 2, Clause B is applicable only to international armed conflicts. Now, it is very, very clear that Article 8, Clause 2, Clause B, paras 17 and 18 apply only to international armed conflicts. And if there is a non-international armed conflict where chemical weapons have been used, then the court cannot proceed against the person or the perpetrator of the crime of using chemical weapons, because this article does not apply. And we do have another provision, that is Article 8, Clause 2, Clause E, which deals with provisions relating to non-international armed conflict. But these crimes which are listed under Article 8, Clause 2, Clause E do not mention chemical weapons or any weapon that is mentioned in Article 8, Clause 2, Clause B is not mentioned in Article 8, Clause 2, Clause E. So here again, there is a kind of a restriction on the part of the court to proceed against perpetrators of the crime. So these are the difficulties that the court faces. Now, the best example is that of Syria. Now, when there was an internal conflict between Syrian forces and the ISIS in 2013, there were reports that chemical weapons were used. But this conflict is not an international armed conflict. It is a non-international armed conflict. And therefore, the ICC cannot proceed. Of course, during the 8-year war, a war was fought for 8 years between Iran and Iraq, where the then president of Iraq, Saddam Hussein, had used chemical weapons against the Kurds living in the north of Iraq. So this, of course, happened, and the court can only prosecute or go against, order prosecutions against activities or crimes that have taken place after the coming into force of the Rome Statute. And this happened during 1980 to 1988. But it has been the biggest and the largest use of chemical weapons in the history of war in the world. What Saddam Hussein did from 80 to 88 in this 8-year war, the volume of chemical weapons that have been used is the largest compared to all other wars where chemical weapons have been used. So when we have such a huge example of the devastation that chemical weapons can bring about to the humankind or the human race, then I do not understand why states are not taking it as a serious crime. And even at the ICC negotiations, Rome Statute negotiations, states should have been more definite, they should have been more concrete in their ideas, and they should have include specifically the word chemical weapon, the use of chemical weapons in any war. Then the court will have jurisdiction. They should have specifically mentioned, but they did not do that. But what little that they have included during the Kampala amendments, there also we have limitations. Because where one provision speaks of weapons which are similar to chemical weapons, applies only to international armed conflicts. The other provision, which applies to non-international armed conflict, does not mention these weapons. So these difficulties are there, but however, another problem is Syria is not a party to the Rome Statute. So the question arises whether the court can order a prosecution against Syria or whoever is the perpetrator of the crime in Syria. Since Syria is not a party to the Rome Statute, there is no possibility of the court proceeding against Syria. However, if the Security Council can make a referral to the court, then the court can exercise jurisdiction. Now, even this, in fact, a draft resolution was presented before the Security Council in 2014 for a Security Council referral against Syria, but Russia and the US, China, both exercised veto and defeated the draft resolution. So even the Security Council referral, which would have helped the ICC to prosecute the perpetrators of the crime in Syria, fell flat. They could not do it. So we do have problems, and now, as I said, use of chemical weapons is a very serious offense. In fact, we do have a convention, that is Convention on Chemical Weapons, signed in the year 1993, and which came into force in 1997. Now, this convention has a long list of weapons which cannot be used in warfare. In fact, the convention bans the use of certain chemical weapons in warfare. So, since the convention was signed in 1993 and came into force in 1997, the Rome Statute was signed in the year 1998. So, the state parties could have taken a cue from the convention and included some provisions of the convention in the Rome Statute for banning use of chemical weapons, and in case chemical weapons are used, the court shall have jurisdiction. This should have been done, but some of the states have failed to do it. So, despite all these drawbacks and difficulties, I sincerely feel that the ICC should have jurisdiction against states who make use of chemical weapons in warfare. That is my sincere opinion. Thank you.
Thank you, Professor, for your participation in this debate. Professor Milton, do you want to add something about what Professor Sripati has shared with us?
Oh yes, Dr. Marotta, thank you very much, Directors, International Programs. But I would like to extend my thanks for a very intellectual presentation by Professor Dr. Sripati, as usual. That was very comprehensive and very, very incisive. I can see that really we are a powerful panel. Now, this discourse that relates to chemical, biological, or nuclear weapons in the context of international criminal justice can be traced way back. I've heard what the professors, analysis the professors provided, very, very comprehensive indeed. Now, mine is simply to reinforce what he has, the professors presented to the viewers and to this panel. I totally agree that the professors analyzed the critical provisions and instruments that are pertinent to this particular discourse. Now, I just want to bring out some issues which should be able to provoke further thoughts between us and further intellectual analysis. Let's start off with, but before I get into the Rome Statute, which is a recent development in the realm of international criminal justice, I want us to look back and examine some of the statutes, rather some of the instruments that Professor Sripathi had pointed out. But before then, I would also want to indicate one thing. The question of language and the canons of interpretation are going to be very critical in this discourse. The canons of interpretation of statutes, of texts. We have various canons of interpretation, of construction of legal texts and documents that relate to issues of international law. And those interpretation exercises ordinarily, invariably takes us back to the Vienna Convention on Law of Treaties. Most of the time, many scholars in this kind of debate would quickly refer to, the Vienna Convention and use it to be able to shield or to fortify their line of arguments. Section 34, 30, I'm not very precise about that, but depending on what line one is pursuing, they would try to have recourse to that. But I would want to pick out one thing from there. We have the literal interpretation of a text. Literal meaning we take it the way it is presented. It may not take into account a lot of contextual basis. We have also an interpretation, mode of interpretation that would allow us to try to have a retrospective glance at how the text came into existence. Now, I will get back to that. I just hinted that briefly. But I want us to look at the other statutes or other instruments that were in place before the Rome Statute came into operation. We have the Biological Weapons Convention of 1972. We have the General Protocol to the Hague Convention, actually specifically the protocol. There was the Hague Convention, of course, of the 1977. And in 1925, we had the General Protocol to that particular convention, which handled the issue of biological weapons, the issue of this class of weapons. Now, what is critical as we proceed with this discourse is that we have to look at whether the instrument bans the development, that is the manufacture, the application, and possession, or use or employment, depending on the verb that has been applied. Because when we come to look at what the Rome Statute states, we would question ourselves as to whether that particular provision, Article 8, 2, paragraph 17, I'm not sure, let me just get the correct one, which I want to refer specifically to. But let's just say, what does the Rome Statute do? Does it prohibit use? Does it prohibit possession? Does it prohibit development? Or does it prohibit all other aspects that relates to that? That would give us a clue. But before then again, I want just to mention another statute. There's Convention on Prohibition of the Development, Production, and Stockpiling of Bacteriology. That was 1972. Remember that convention specifically prohibited the development of bacteriological weapons, which obviously using the same parameter my colleague, my professor, Dr. Sripathi said, it's a matter of, I would say, semantical gimmicks, linguistic agility, because it may not use a particular word, but that would be synonymous with the use of another word or as a synonym. All right. This particular convention, as we can see, specifically prohibited to develop. But when we look at the Rome Statute, as we shall come to see, nothing talks about the development. It only seems to rush to prohibit the use, the employment, which is the use of a particular weapon. Okay, we are not going to delve into most of this. I don't want to delve into this. I'm just drawing your attention to the attention of the panel and possibly the viewers who are interested in following this line of argument, that there are other conventions that were in place. There are others that have prohibited the proliferation. Most of these have been multilateral, of course, in nature, given the gravity of the weapons and the consequences. Now, let's get right onto the Rome Statute. My colleague, Professor Dr. Sripathi, has said enough. I need not add more onto what he has said. Only I want to point out one thing. When we examine closely, when we read positively, read and construe Article 8, 2B, 17, we can see that it bans the use of poisonous or poisoned weapons. Let's try to look at that. A similar provision which is related to that is the next one, which is para 18, which it says the war crime to use asphyxiating, poisonous, or other gases. The way I agree totally with the way Professor Sripathi indicated, that the use of this, what are these? The first thing you pose yourself, what really are these gases? What are these poisonous items? How do you classify them? Are they not weapons? Are they not chemicals? Would you argue that they are not chemicals in any case? Would you argue that they're not, chemicals particularly? When you talk about gases, well, how do you classify them? A broader classification would be that they're chemicals. But I want to take that argument a little bit further. Let's try to look at the historical context, because literally this is what it is. Literally, again, one would argue that if it was the intention of the drafters to incorporate the word chemicals or biological or nuclear openly, nothing would have stopped them from proceeding so. That has been a common statement. Some of us as drafters, I'm a legislative drafter as well. So when we draft, we would always say, if it was the intention of the drafters that time who drafted the instrument to do that, nothing would have stopped them than just to specifically state that. That is more of trying to advance an argument in favor of literal interpretation. But that is not the only interpretation avenue available. So usually we'd want to go back. Let's get back to the drafting time. We look at the travaux préparatoire that existed. What was the intention? One would argue, some scholars would say, but it's not easy to know the intention of 120 states. How would you discern that? But it is clear at the time of the drafting, there was a debate. You'll all agree that there was an argument as to whether to include chemical weapons, biological weapons, vis-a-vis another argument as to whether to insist on nuclear weapons being introduced. When you look at this classification, it would appear that chemical and biological weapons were much more available to the less impecunious, the more impecunious states, the poorer states, the general, states, as compared to nuclear weapons, which was the preserve of the rich and wealthy states. There was a debate during that time, indeed, where people argued that it would be unfair, inequitably speaking, to prohibit only biological and chemical weapons while not prohibiting strictly the nuclear weapons. Because somehow the wealthy states had stuck to their nuclear weapons for one reason or the other. They wanted to retain them. But when you analyze also the provision, it does not talk about the retention, the possession. It wasn't prohibiting the possession. So the wealthy states, for instance, the United States, India, and China, all these had, Dr. Sripathi will agree with me that India is one of the most powerful states in the world and very quiet.
France also.
Yeah, France indeed, absolutely. They did not, nothing. It's like they wanted to stick to their weapons. None of them would be willing to proceed to have to advance the prohibition of the use of their weapons. So some class of people argued that why would we insist on banning biological and chemical weapons, which are easily accessible to the poor, and yet we are not addressing the nuclear weapons? So you see the term there is, they're not even talking about possession. Nobody's talking, so how do we prohibit something which can be freely developed? It's like saying you can come into the room with a cobra, but we allow you, that is not, it's not an offense. But to allow your cobra to bite someone is an offense. Why do you allow such a person in the first instance to come in with a cobra? So this was the complication about these weapons. And so there was an argument at that particular time that really it would not be fair to prohibit two chemical and biological weapons while not doing anything about nuclear weapons. It would be favoring the wealthy while the poor would also have their at least something more mass destruction item, be able to, okay, sorry. Yeah, so in effect, what we are saying here is, at that particular time, there was lack of agreement as to whether to incorporate this. And so the idea was abandoned. It was not included. So we can say explicitly, it was abandoned, but the reason for its being abandoned, including this, would mean that if that argument was prolonged further, it would delay the passing of the Rome Statute. It would actually impede all the efforts or frustrate all the attempts to finalize the statute. So it was left, it was not included. And again, to proceed to reinforce what my colleague, Professor Dilipathy, very ably put, he brought in the issue of the review conference. 7 years later, the year 2010, rather, to be more precise, in Kampala, when the review conference sat, the war crimes was one of the other areas that they focused. And this issue, as Professor Silpathy has ably put it, was also again on the table. But to be more specific, Belgium sought to introduce an amendment. The state of Belgium was interested in having to have the provisions amended to include all these other items that have been skipped relating to weapons of chemical, biological, and nuclear. The same argument was advanced during this conference. It was seen during that short time, it was not possible. In fact, the idea was altogether abandoned in the end, because to take one side and abandon the issue of nuclear, focus on biological and chemical weapons while not addressing nuclear was going to be a real prolonged debate. It was to resuscitate the debate that was going on at the time of the drafting of the Rome Conference. So we see that the attempt by Belgium to have the same definition introduced was abandoned, so that there could be consensus. There was actually no consensus on this item, but the consensus was there on the other items of amendment. So we see two things here. At the drafting of the Rome Statute, specifically the issue of chemical weapons, though introduced, and biological was abandoned. And again, another second attempt where Belgium spearheaded the amendment, the same was abandoned. So the question that we ask ourselves, should we ignore the intention of the drafters when coming to interpret this text? Should we simply overlook? Because we can see that the intention of the drafters was clear, not to include chemical. We cannot argue, for instance, or extend the argument that possibly the drafters intended, but they didn't have time. No, whatever they intended was replicated, was actually represented on the text. So the question that we would be asking ourselves is, was it really the intention of the drafters or those who sought to amend the draft that they had to be able, was it the intention to include chemical, nuclear, and biological weapons? That's a very taxing question. As I was saying, Dr. Marotta, just in a statement, at the time of the drafting of the text, it was clear that this issue of biological and chemical and nuclear weapons was deliberately left out in the interest of proceeding with it, because otherwise that debate would have gone on. There are people who had vested interests. There were very powerful states that had vested interests, and would not allow that. They wanted to stick to their nuclear weapons. They would not allow a situation where their nuclear weapons would be, grabbed away from them or prohibited for that matter. They would also argue that there were other instruments or conventions that were dealing with the issues of proliferation and the rest of the things about those weapons. And I've just stated, what's important that I stated in your absence is that Belgium, remember Professor Sripathi talked about the Rome Conference review. That was 2010 in Kampala. Belgium trying to introduce another amendment to be able to bring in the issue of chemical, biological, and nuclear weapons. But, all right, but very clearly the debate was abandoned. The arguments already being brought again that why do you focus on biological and chemical weapons, which is easily available to the poor nations? And definitely those who possess nuclear weapons will be very reluctant to give in to their weapons for their own reasons. So that debate was not sustainable at that particular time. It was abandoned for the sake of winding up and adopting the other things like crime of aggression, which were more pressing. So that leaves us with a question. If at the time of drafting of the Rome Statute, the parties were not able to include, they expressly failed to include those weapons, to prohibit the weapons related to, specifically to use the terms biological, chemical, and nuclear weapons. And also at a subsequent review in Kampala, they failed to agree to put those. Can we argue that it was still the intention of the drafters to have this text reflect those three classes of weapons? That is something debatable. Debatable because if I pick up what Professor said very clearly, that how do you classify, how do you call poisonous gases? Are they not chemicals? How would you classify as obfuscating substances? Are they not chemicals? Or are they biological? And to add on another text, which I'm not sure that my colleague might have mentioned, when you look at Article 2A of the Rome Statute, let me just get that article right from the Rome Statute. Yeah, the same Article 8, paragraph 2A, 2, which talks of torture and inhuman treatment, including biological equipment. You see, how do you torture someone or have an inhuman treatment relating to biological experiments, including biological experiments? If you're carrying out a biological experiment, there's a biological element already in there. You're using biological weapons or instruments or some items. So I'm trying to reinforce on the argument of Professor Sripathi that really we have to look at what are these that we have in the text. Are they not biological? Perhaps it was a question of semantic or linguistic agility as to not to bring out clearly. There's lack of clarity as to whether to use weapons. What are we talking about when we say biological weapons? And here we are talking all chemical weapons. And yet, Article 8 clearly mentions items which would be classified gases, liquids, which are analogous, which, as the professor put, would all be classified as chemicals. That is a debatable issue. So that can be carried on too. But the issue again is, why would the drafters not include this expressly and just say, from now on, we prohibit the use or development of chemical and biological as well as nuclear weapons. But the other argument would be, if they intended to have that, nothing would have stopped them from having that. But we know from history, from looking at the Travaux Préparatoire, that actually there was disagreement too. So the other question that comes out, can the court arrogate to itself jurisdiction? Can the International Criminal Court argue that, well, in our view, this is what the drafters thought, and make it an authoritative jurisprudential point? That is debatable too. Can the court declare something that was clearly, even in the records, in the historical records, was denied, was actually kept off, was refused by those who are entrusted in drafting? Because those delegates are the epitome of their respective nations. They are the representative of the 120 nations that approved. I said that was the intention of those nations, those states that approved the text in its current state. So there are a lot of debatable issues that arise from this. And so as we proceed further, I would want us to look into the issue of, is there, just to summarize, notwithstanding that at the Rome, drafting of the Rome Statute initially, this particular mention of chemical, biological, nuclear was expressly excluded. And secondly, the German amendment proposal at the review conference was overtly rejected. Both of them on the ground that if that debate had to go on, it was very unlikely that those who hold nuclear power or weapons would not agree, would not succumb, that would not accede to any interests that would try to, deny them the use. So, notwithstanding all those experiences, can we say, can the court or anybody interpreting the statute still argue that, well, that let's ignore that and take it in the context of what we have at the moment? So where do we get the authority to back us if we take this argument, which I agree, very persuasive? I would also say no, but what do we have? What are we dealing with? What was the spirit of the Rome Statute? Just to address issues that would bring, the A, B, C, and C, and we have this so far. So that is something that has to be addressed effectively. If those failures were there, actually manifest in those two instances, can we still argue that we can still ignore those manifest failures to introduce these items and interpret the Rome Statute as if it prohibits chemical weapons, it prohibits biological weapons, and it prohibits the use of nuclear weapons? Can we say the Rome Statute empowers, because I'm going to refer to another section, I think it's Article 120 something of the Rome Statute, 121 or something, I'll come to that. But can we now say the Rome Statute empowers the ICC to decide to examine issues relating to chemical weapons, like in the Syria instance where there was violation, overt violation in terms of chemical weapons or whatever weapons it is in question? Can the ICC on its own say we have authority over all these issues? Would you think the pretrial chamber would be able to pass such an argument to ignore what the drafters in the 1998 statute time had actually overtly rejected to bring, and which in 2010 did not bring in? Can they say, if we look at this context, the statute as a whole, and the context and the spirit of this statute, we have the mandate to be able to, examine, to have jurisdiction over these offenses? That is highly debatable. And we cannot simply ignore, we cannot say there's one way of arguing and agreeing to this. So that is what I throw back to you as professors. You may want to add on something on that. Perhaps the other thing that I would want us to look at also, what is the status in all these arguments that we have? We know we have the interpretation also of the International Court of Justice on the issue of these weapons. We'll come to look at that at a later time as well, bring it up. But what is the nexus between all these provisions with those other conventions? We have just alluded to the Geneva Convention, the Geneva Protocol to the Hague Convention. These are conventions that also deal with, we have the ones that deal with Biological Weapons Convention. We have the nuclear proliferation arrangements between certain states. What is the context of the Rome Statute in the light of all these other conventions that also address the issue of nuclear weapons and biological weapons and chemical weapons? So this is what I put back to the professors, and I would be interested to hear your views. Thank you, Dr. Marotta, and thank you, Professor Sripathi, for a very erudite presentation. Over to you.
Thank you, Professor Milton, for your participation. I will pass the desk to Professor Sripathi.
Yes. Thank you, Professor Milton, for your clear-cut analysis of the Rome Statute, the provisions of the Rome Statute, what went into the deliberations when states wanted to include chemical weapons. Clearly pointed out that chemical and biological weapons are easier to acquire than nuclear weapons, because nuclear weapons is an expensive affair, and only a few countries in the world have nuclear weapons. And as you mentioned, we have US, China, Russia, and Pakistan. It's a small country, but still possesses nuclear weapons. North Korea is which has nuclear weapons.
Your country, and India, has it as well? Yeah.
North Korea, yes.
India. Korea. India has it.
India also, yes. India is a nuclear power.
Very, very powerful, but silent.
No, but India adopts a policy, no first use policy in case of nuclear weapons. What India says is, we will not use nuclear weapons first. But if some state uses nuclear weapons against India, then India will retaliate.
Yeah.
We have that policy, it's very clear.
Powerful.
So, and we also have CTBT, Comprehensive Test Ban Treaty.
Yes.
As far as nuclear weapons are concerned, where under this treaty, testing of nuclear weapons under the ground, in the space, and underwater. All three kinds of testings are banned. States cannot test. But still we find France and China conducting tests and being permanent members of the Security Council of the United Nations. Clear-cut violation of the United Nations Charter. But as I said earlier, these are international politics.
Yeah.
India, of course, conducted 3 nuclear tests about, say, 20 years back in Pokhran, one of the states, Rajasthan. We have a desert, and the nuclear tests were conducted in the desert. But mostly India uses all its nuclear energy for civilian purposes, not for military purposes. Now, coming to the Rome Statute itself, nowhere does the Rome Statute speak of nuclear weapons. Now, as pointed out by Professor Milton, with regard to the deliberation that went on during the 1998 negotiations of the Rome Statute, biological and chemical weapons and nuclear weapons, if all 3 weapons, the use of all 3 weapons, if it amounts to a crime where the ICC can exercise jurisdiction, then no state would definitely act. So what the state should have done is taken it in a phased manner. Initially consider use of chemical weapons as a war crime, in respect of which the ICC can exercise jurisdiction. Later on, in the second phase, include biological weapons as a war crime. And then lastly, they should have gone after the nuclear powers, saying that even use of nuclear weapons should be considered as a war crime, because nuclear weapons have a more devastating effect than chemical and biological weapons.
Yes.
So use of nuclear weapons also is a very serious crime. So they should have done it in a phased manner rather than put all the things together, because one can be 100% sure that the states will not accept if all three are to be banned. So it should have been done in a phased manner. And moreover, coming to the Rome Statute itself, the Rome Statute does not anywhere mention nuclear weapons. It mentions poison and poisonous gases, asphyxiating gases, and other liquids and materials analogous to such gases. Now, as far as nuclear weapons are concerned, they are developed from radioactive metals. Radioactive metals such as thorium, plutonium, and uranium. So there is no mention of these radioactive metals anywhere in the Rome Statute. And the provisions that deal with chemical weapons are very, very limited. There are only two provisions in the whole of the statute that speak of not exactly chemical weapons, because the words chemical weapons have not been used. Words similar to chemical weapons have been included in the Rome Statute. And the deliberations in 1998, when the states discussed these, a lot of issues were there, and many states wanted chemical weapons, the use of chemical weapons to be a war crime under the Rome Statute. As I mentioned earlier, the states went back because simply banning chemical and biological weapons and not banning nuclear weapons was just not possible. So, and since the arguments and deliberations with regard to these chemical and nuclear weapons would only delay the coming into force of the Rome Statute if the deliberations had continued, and states were eager that the Rome Statute should be finished and then established. So probably they put aside this particular aspect of chemical and biological weapons. Even during the Kampala amendments, somehow the states managed to include those two amendments, that is 17 and 18 of Article 8, Clause 2, Clause B. And they could not proceed further, mainly because of the fact that there was another pressing matter, as pointed out by Professor Milton, that of crime of aggression. The definition of the crime of aggression was more important at that point of time during the Kampala amendments. And they devoted more time towards discussions on the crime of aggression. So this again was sidelined. So that is how today the Rome Statute having two provisions, but these two provisions also have their drawbacks, very restricted, because one provision applies to international armed conflicts and the other provision applies to non-international armed conflicts. So while one which speaks of international armed conflicts speaks of weapons similar to chemical weapons, and the provision that deals with non-international armed conflicts, the list of crimes under this provision does not mention anywhere the provisions that are contained in 8, 2, 17 and 18. So 8.2e, which deals with non-international armed conflicts, does not speak of those crimes or use of those substances. So I've discussed all this, and then we have this other issue of certain states not being a party, but still court can proceed against those states provided a referral is made by the Security Council to the court. And in fact, in the case of Syria, though it is a non-international armed conflict when chemical weapons were used, and a reference was made to the Security Council, but somehow two countries have used veto. It is China and Russia, yes. And the resolution was defeated, and reference could not be made to the ICC to proceed against Syria. So again, the court has come back to zero. The court is trying to do everything within its powers, but because of these inherent drawbacks within the statute of the court, is not allowing the court to function smoothly and efficiently. So, at least in the future, a lot of, I think, definitely amendments must be made to the two provisions of the Rome Statute. Amendments must be made, and the provisions must be more clear, clearly stating that the use of chemical weapons, and they should give a long list of all the chemicals amount to chemical weapons. Again, if you mention one or two chemicals, the states might use other chemicals and say it is not part of the Rome Statute.
Yeah.
Let us be comprehensive in drafting the provision by including all the chemicals that can be used for developing chemical weapons. Similarly, biological weapons also, because as far as biological weapons are concerned, there is no mention in the Rome Statute. Very restricted. So biological weapons also should be listed in a very clear manner, a long list. Countries which use these chemical and biological weapons during warfare will not go scot-free, and they will come under the jurisdiction of the ICC. They have to. At least we expect this from the court in the near future. Thank you.
Thank you, Professor Sripathi. There are a few things that I want to follow up immediately. You've mentioned, with your permission, Dr. Marotta.
Yes. Continue, Professor Newton.
You have something to come in through? All right, let me just catch up when it's still hot. You've mentioned something which is clearly what I wanted to talk about earlier. So I thank you very much. The issue of definition. It is very critical if at any point we're going to have an amendment or drafting, the definition of these terms, the definition clause, the interpretation clause, as it is called.
Interpretation clause, yes.
Should be able to bring out clearly what is meant by chemical or what's meant by biological. That would be able to, because if you're going to look at the interpretation of the statute as a whole, there are so many elements that have to come into play. One of them would be the spirit. What's the spirit of that statute? When we look at Article 1 of the Rome Statute, it talks of the courts. It would be interesting, before I even mention that article, it would be interesting to really see the reasoning of the ICC, of the judges, should such a matter come before it. I suspect that one of the reasoning could be the court would want to argue, or there could be an argument that when you look at Article 1 of the Rome Statute, it says the court shall have jurisdiction over persons for more serious crimes. There are two things here: serious crime as one, serious crimes that are of concern to the international community. So the question would be, do we consider chemical weapons, the use of chemical weapons? And we have to be careful whether what is being prohibited here, is it the use or the possession? Just as I gave the example of a cobra. Are we prohibiting the use? Because it seems even in these two elements you're talking about, what is prohibited there is just the use. Nobody's prohibiting the possession. Nothing, it doesn't talk about possession. But then back to this Article 1, the court could still argue, just hypothetical for analysis, for argument purposes, for analysis purposes. It could argue that, well, the statute establishes us to be able to have jurisdiction over persons, for one, more serious crimes, and two, of concern to the international community. So can we use these two elements to interpret as to whether we have jurisdiction over chemical weapons, nuclear weapons? So the question is, are nuclear weapons, the use of nuclear weapons, a serious crime? Would it be really serious to launch a nuclear weapon onto mass populations? The answer would be positive. It would not be in the negative anyway. Then they would also ask themselves, is it an offense that is of concern to the international community? The answer also is in the affirmative. I'm just using this hypothetically for analysis purposes, argument purposes. That yes, so in that case we have authority, we have the jurisdiction over these persons who are using these items. But those are all debatable. Now, the other element which I want to introduce, which I did not mention in the first instance, what is, as we look at this, would question ourselves, what is the role of the customary international? What's the position of customary international law? What's the role of this customary? Where the opinion risk comes in? How does the issue of nuclear weapons, biological, chemical, fall in the context of the jurisdiction of the International Criminal Court? That also needs to be looked at. And another thing I wanted to make clarification was, okay, definition, I've talked about that. It's very clear that if, to avoid ambiguity, to avoid absurdity in any interpretation, it would be critical that any amendment that we put in would clearly bring in what is entailed under the umbrella of chemical weapons, even nuclear weapons. Because if we, the way Professor put it already, some of the uses of nuclear weapons or nuclear energy is for civilian uses, harmless purposes. So it's very clear we cannot have a blanket prohibition of nuclear. It's critical that we should have very clear definition, an interpretation clause, or that clause can also be within the Article 8 itself and interpret and say, for the purposes of this article, the following words would mean this and that and that and that, and include this. It can either say includes this or would mean this. Usually in drafting language we choose which one depending on what we want to embrace within that term. So that is very important as we look forward, because I can see that it will not end in future without this being brought in expressly within the statute at some point. And talking about that, I need to clarify also that actually the amendment which the Belgians brought before the 2010 Review Commission.
Kampala amendments.
Yeah, Kampala, actually, the Kampala Review Amendments. What the Belgium state brought, the amendment they proposed was only to amend to include chemical and biological weapons. And the reason there was contest and resistance to this was that there was no mention of nuclear weapons. So that has to be very clear. The amendment did not talk about specifically about nuclear weapons. So the argument was, why are we leaving out this? Because then it would not be fair. To bring in those amendments would mean clearly targeting only the poor countries that would not be able to afford the nuclear weapons. But we know that even the lobbying and even the presence of the United States was present. The fact that it did not sign the agreement, it did not ratify, it was still present as more of an observer in that conference and was there to be able to see that their interests are protected. So we would expect resistance from the nuclear powers. The arguments would have gone on, so they decided to shelve them all together. But it's clear to note that Belgium had somehow omitted the issue of didn't give emphasis to nuclear weapons. That was the argument. That really, why can't we then also bring in the nuclear weapons as a prohibition? The other point is, as I said over and over again, if you look at the statute, it only prohibits the employment, which is the use or the application, as you name. It does not tell us that the development of this is prohibited. In my view, a very comprehensive, if we seek to block off or stall something that is a mischief, we should be able to address the issue of the development of that particular prohibited item, not just the employment of it. Okay, the other issue we need to look at is how we position the Non-Proliferation Treaty of the 1968 in all this context. I've just asked, how do we deal with customary international law in respect of this? Now we are talking about Non-Proliferation Treaty. We are also saying, where do we put in the Biological Weapons Convention and all other conventions, the chemical weapons that relate to this? The context is very critical. So it is clear also that we should re-emphasize that so far, the ICC, going by this, it can be argued it has no jurisdiction really over these offenses. At the moment, any offense that relates to use, because these offenses could have been generated by other conventions or other statutes, or internal domestic legislation anyway. But the question is, can the ICC argue or deny itself jurisdiction in the light of Article 1 of the Rome Statute? That's a question we need to look at as well. And I just said that article simply, there are two elements I'm removing out of that Article 1 for purpose singling out. That is the most serious, it has jurisdiction of most serious crimes. So the question would be the use of nuclear weapons and the use of biological and chemical. They're not serious. Two, which is of concern to the international community. Are they of concern? Yes. All these answer in the affirmative. And so can the ICC argue that in the light of that, if we are going to look at the provisions in Article 8 and apply it to the Article 1, do we have the jurisdiction? Okay, so it's clear. We also need to look at Article 121. But for now, let me just state that the arguments advanced by Professor Tripathi were very, very informative. And the analysis should continue to proceed in the light of those areas. Let me hand you back to Dr. Marotta.
Yes, thank you, professors, for sharing with us your thoughts and your experience in the matter. Also, what I want to add is related to customary law is that also I was thinking about a Ratbruch, this German scholar, that when we had in the past the Nuremberg trials for getting in prosecuting the Nazis regime, he developed a formula that is called the Ratbruch formula, that was the Ratbruch formula propounded the notion that positive law must be regarded as a contrary to justice and not apply where the inconsistency between statute law and justice is so intolerable that the former must give way to the latter. This concept was applied in the German Federal Constitution, referred to the formula in its judgment in Strasles and Kester in October 1996. The question at issue was whether the accused former senior officials of the former German Democratic Republic charged with the indictment to commit intentional homicide for the responsibility in ordering the shooting and killing by border guards of persons trying to flee from the GDR at the material time, which did not make them liable to criminal prosecution. The defendants admitted that holding them criminal liable would run contrary to the ban on the defendants admitted that holding them criminally liable would run contrary to the I was related to the retroactive application of criminal law under Article at that moment 10302 of the German Constitution, laying down nullum criminal principle. The principle said that there is no crime if there is no statute law related to the crime. The court in this case dismissed the defendant's submission, among other things, if noted that the prohibition on retroactive law derived its justification from the special trust reposed in criminal statutes enacted by a democratic legislature respecting fundamental rights. So here, what I want to point out is that under the Ratchford principle that was used in the Nuremberg trials, and afterwards part of the foundation of the custom and jurisprudence and doctrine through the German scholars, we should use it also here in the ICC related to chemical and biological weapons. I think that trying to make that approach, and all the states around the world, or even a few ones, try to hold this idea of being more specific related to this type of crime, biological and chemical. It will aid in the future also for stopping the nuclear under the nuclear. I mean, there is this clock that is called this name the midnight. It's called the clock. There is the atomic clock bomb. It's called 5 minutes to midnight. So if you go to the webpage of this clock, you will see that we are like 1 minute before the midnight. Yeah. Yes, I mean, this webpage is very amazing. Yes, the one went to 1 minute. So I think that if some countries that are now part of the Security Council of the UN try to make another Kampala Convention trying to discuss this issue related to massive destruction armament, it will be very helpful for example, India, Pakistan, and all the countries that have nuclear material. They can be, as Professor Shipati has enlightened us, that can be like what they use in India is more for energy, for having a power station and be used for that, not for weapon, and trying in some point to disarm all the countries around the globe with the nuclear power of mass destruction. I think that there should be an initiative, I don't know, from any country around the world, trying to have an honest view of disarming the biological weapons and the chemical ones, including the nuclear that are considered with the chemical weapons. So that's what I want to share with you.
Yeah, thank you, Dr. Marotta. That was good. That was you're always giving us pertinent live situations. Now, there's something I mentioned. You remember I mentioned Article 121 of the Rome Statute. I said we'd get back to it. That particular article. But before I go on, I think it seems that no one of us is in a hurry, but if one wants, I thought that limitation of 1.5 hours may not be working for us. I don't know what you think, Dr. Marotta.
Yes, I haven't heard the.
Yeah, I said, are you with me?
Mm-hmm. Yes, I'm here with you.
I was saying that limitation I was trying to indicate of 1.5 hours may not be working, because sometimes this discourse becomes, very more interesting towards the end. All right, we'll allow ourselves to exhaust whatever we want to exhaust. Article 121 of the Rome Statute, generally, if you look at it, generally deals with amendment procedures.
Yes, correct.
Yes, so I talked about it. I said we need to have a look at it as well. It provides for amendments of the statute. If you look at Article 1, after the expiry of 7 years from the entry into force of the statute, any state may propose amendments. That's why we didn't have amendments until, you remember, the first review conference in Kampala in 2010.
Yes.
Yeah. So that it provides also for such that the text of the proposed amendment shall be submitted to the Secretary General of the United Nations, who shall promptly circulate all states. The other important date within this article is the issue, figure is the issue of 3 months, at least 3 months from the date of notification. The Assembly of State Parties, the ASP, at the next meeting shall be able by majority present vote over it. And it's important to note that some of the decisions would be moving by way of consensus, but where consensus fails, then 2/3 of the majority will be able to deal with certain amendments. We are talking about this to be able to alert the states who are watching and our viewers. Is critical because we advise states also on matters of international criminal justice. The other point which is critical to note here is where consensus cannot be reached, it will require 2/3 of majority. I've just mentioned that. As well as if it takes 1 year, or just to read it clearly, apart from that, we would have the review conference. The review conference can be convened as it was in 2010, but only after 1 year, after the first point was 7 years. After the 7 years had elapsed, then I was trying to explain that that is the reason we never saw any proposals until after the Kampala Amendment. And so people are to contend. Probably the rationale there was to allow for states to evaluate and reassess and see the proposals in action. But again, we see that all these amendments do not just proceed general. They're not general terms. There is Articles 5, 6, 7, 8, which of course we know deal with the crimes and the elements of crimes proscribed under the Rome Statute. You look at that, an amendment to this shall enter into force for those states which have accepted the amendment 1 year after they have deposited their instruments. Okay, my interest is one thing. All these questions, all these arguments we have put across, maybe we'll also want to hear from Brian, the researcher. He just told me he's been having, how are you, Brian? We didn't even greet you. We're deep into the, are you okay? You can hear us?
Yeah, you're audible, sir. Thank you very, very much. Am I audible?
All right, so I'll soon hand over to you, so get ready. We want to hear your views. I'm sure you prepared something. But the arguments, some of which went on in your absence, were that the statute does not bring out clearly that it prohibits the use of biological, chemical, or nuclear weapons. What we saw, as Professor Sripathy put very, very clearly and elaborately, is arguments about how they talk about gases. And anybody will say, but these are actually chemical weapons. And the interpretation is clear. You cannot deny that. You cannot simply say that they are not chemical weapons or they are not biological for that matter. So we looked at a number of analyses in your absence, in your short absence. But the point here is, does the court, the International Criminal Court, have jurisdiction over matters relating to chemical weapons or biological weapons or nuclear weapons? We also said that the amendments introduced by Belgium, proposed by Belgium to be introduced at the Rome conference, at the review conference in Kampala. But they proposed that we should be able to ban chemical and biological weapons. However, those who are present contested that proposition because it did not talk about nuclear weapons. And it was argued that nuclear weapon, it appears it was favoring only the richest states like India, who can afford to have nuclear weapons. And the biological and chemical weapons are largely for the less infectious. Those are a lot of arguments that went on. In the end, what I'm saying is we should be able to ask ourselves, can really the International Criminal Court argue that in the light of Article 1, which says it shall exercise jurisdiction over persons for the most serious crimes, 1, and which are of concern to the international community, 2. But we see that all these biological, chemical, and nuclear weapons are serious. Nobody can argue that they're not serious crimes. No one would argue that they're not of concern to international community. Can the ICC use that particular interpretation? And in the light of the chemical weapon, because it could interpret that since it's prohibiting this, one would argue at the Pretoria conference when they're probably trying to establish jurisdiction, the prosecution could argue that, for instance, that, Article 1 empowers the court to be able to look into this. 2, they could argue also that since there have been mention of these chemical weapons, analogous liquids, we can also argue that it was the intention to bring in the other items, which are chemical and biological. And the other thing could be, in this particular argument, was that at the time of the drafting, it was clear that there was an attempt to bring in these chemicals, biological, nuclear weapons to be incorporated, but those attempts were thwarted, and that's why they don't exist. And so if the court proceeds, it will be arguing contrary to the intention of the drafters. These are the kind of discourse that have been going on. But before we go to the conclusive things, we would want to hear if you have anything to add on. Let me just hand you back to Dr. Marotta to run that part of it. Yes, Dr. Marotta, back to you. Probably you want to bring in Mr. Brian.
Okay, Brian.
Thank you very much. Am I audible? I'm having network problems today. Data this side is very expensive. I have 2 submissions. Firstly, on the issue whether or not the International Court will have jurisdiction, is going to be a matter of which method of interpretation is going to be employed by the court. So if the court is willing to take a purposive interpretation to say that the words that are used in Article 8 then it would mean that the court would have jurisdiction. But if the court is going to use a more restrictive approach, then it would mean that the court does not have jurisdiction. So the most interesting clash is going to be the fact that if you look at Article 32 of the Rome.
Yes, we can hear you.
If you look at Article 32 of the Vienna Convention, it states that, yes, it states that the intention of the drafters should not be the primary requirement that is used to check whether or not, or to check the intention of the state parties, but rather we must look at the context or the text of the international instrument. So if we are going to interpret the text of the international instrument, it can be argued that it had the required intention to include biological and chemical weapons. On the other hand, one may also argue that looking at the intention of the parties at the time, because if you can look clearly throughout history, it was not the first time the international community had said and talked about biological and chemical weapons. They said in 1907, they said in 1925, they said in 1972, and they also said in 1968, in which they tried to show their intention to curb this biological and chemical weapons. So the question is going to be, if during the drafting of the Rome Statute in '98, where countries had declared that intention that they do not want biological and chemical weapons to be included, can it be argued that then the International Criminal Court has jurisdiction. So it's a matter of weighing the two arguments and seeing which one will subsist. But I am of the opinion that it should have jurisdiction, looking at a more progressive interpretation of the statute, to say that if those words are included in Article 8, then it would mean that the International Court should have jurisdiction. Thank you.
Yes, that is very brilliant, Brian. I want just to quickly talk about the Article 32 of the Vienna Convention on the Law of Treaties. It is true that all of us would want to be able to look at how the context of the statute is, or any instrument that is being interpreted. But something I want to put across, the modern interpretation of Article 32 of Vienna Convention does not altogether throw away the issue of travail. It's not hostile, actually. That interpretation is not hostile to travail préparatoire, as it is. One would say it's very helpful for us to be able to contextualize. But in the light of how we look at Article 32 lately, it's not that it is really hostile to the fact that we should go back to the, to be able to see what was the intention of the parties at the time of drafting. More so, nothing more, nothing less. That's very critical, but it's very important, as you put it, like all of us agree, even with Professor Sripathi, that we should be able to contextualize that's why I brought in the issue of Article 1 of the Rome Statute, and also just Article 8 itself, which talks about this, the question of weapons should be construed to give it a purposive object. I just wanted to warn that we should be careful not to altogether abandon the idea of the travail, especially and notably where it was controversial and repeatedly an attempt to introduce a particular provision failed altogether. Like in this case, at the drafting itself, it is very clear that there was an attempt and which was expressly denied at the very beginning. It was abandoned altogether. The use of nuclear weapon, chemical weapon, biological, they were not included. And a further attempt in 2010 by Belgium to introduce the same biological and nuclear weapon, very clearly documented. They were rejected on the argument that why ignore nuclear? And the reason was that it favors mostly the rich. And so altogether it was abandoned. So the question would be, why would a tribunal proceed with impunity to ignore what has been repeatedly re-emphasized at the time? So in instances where we cannot fall back to the travail préparatoire, it's very clear that the court would always want to look into the context, the purpose, and as I said, the spirit of the instrument itself by looking at Article 1, where I gave the example that we need to, when you look at Article 1, the court shall have jurisdiction over persons for more serious crimes, one. So nuclear weapons, chemical weapons, biological weapons, not serious crime. It would also go a step ahead and concern itself whether it is it's concerned to the international community. These are instruments, approaches that can be used in construction of text to be able to proceed. And that's why I'm putting across, can the ICC actually proceed to preside over? Can the pretrial chamber rule if presented? Because we don't have any authoritative jurisprudence so far on this matter. And one could easily introduce it. We could actually champion it as a center, inspire one of the states to introduce that motion. We can ask for amendment to be introduced. We can lobby around, because that is why we are here. We can lobby so that states can propose it to the ASP and go through that process and have it introduced. So I want us to just be very careful. That was a very brilliant point you brought in, that the purposive idea of, it's clear to look at what was the purpose and the spirit. But I just wanted to warn that the fact that the literal interpretation should not altogether ignore. The whole thing is about, we contextualize case by case and we give factual interpretation to a given case at a given time. This particular one, we have well-documented rejection of the use of those terms at the time of drafting. So that was very good. And just remember that Article 32 of the Vienna Convention Law Treaty is not hostile to travaux preparatoire. It's not hostile. It will only come into play depending on how. If nothing was ever mentioned about these weapons at all, if there was not even an attempt, would comfortably say the court may have jurisdiction. That's why we keep questioning ourselves, can the court attempt? And that's the question I still put across. Do you think the ICC can proceed to rule the pretrial chamber for that matter if presented with facts for analysis purposes? If presented with facts trying to introduce the issue about weapons that have been prohibited. Can it give itself, can it rule that it has the power to be able to preside over? Does it have jurisdiction over these matters? That is the question. So you look at 121, as I said, just for the purpose of the amendment procedures. Then if you have looked at the 1996 ICJ advisory opinion, I'm not sure that any of you have had the benefit of looking at this, but the advisory opinion on the legality of threat of use of nuclear weapons as a war crime under Article 8. So just try to examine the ruling, the advisory opinion that was granted by the International Court of Justice, not ICC.
Justice.
Yeah, Court of Justice, 1996. That one would be very instrumental. But as a whole, as we said, the issue of, there's also the proposition by Mexico at the ASP, the 8th Assembly, on the amendment of the use of threat to use of nuclear weapons. That will also need to be examined. So back to you, Dr. Marotta. I think somebody else wants to proceed.
Okay, thank you very much for reminding us of the legality of the threat of use of nuclear weapons that was mentioned more than 20 years ago by the International Court of Justice, trying to, I think it was there. To our viewers, you can check more deeply the information in the webpage of the International Court of Justice /case/95. So it's important that our audience and our participants at some point take a look to the communication of the International Court of Justice related to the use of nuclear weapons. And that can be the point of the iceberg related to the other mass destruction weapons related to chemicals and to biological ones. Okay, so at this point, just for ending this panel. One of you want to add something else that we must miss related to this discussion?
I would like to add one point.
Okay, yes, you have the desk, Professor.
Yeah. All this, Professor Milton has given us a very good analysis of the provisions of the Rome Statute. He has established a link between Article 1 and then Article 8, and also a link between the provisions of the Rome Statute and the Convention on the Law of the Treaties as far as interpretation is concerned. But I sincerely feel that if the court is going to proceed against persons who make use of chemical weapons in warfare, it is not enough to merely proceed against persons who use chemical weapons or nuclear weapons, even biological weapons. It it is also important for the court to establish its jurisdiction over those persons, whether artificial or natural. Because chemical weapons, nuclear weapons, and biological weapons are manufactured in factories, companies,
Yeah.
which constitute artificial persons. No doubt, these companies and factories are headed by individuals, but even the country where the factories are stationed, if they manufacture and supply these weapons to other countries, should be brought under the jurisdiction of them. It is not enough to say that only the use of chemical weapons will invite the jurisdiction of the court. Even the manufacture and supply of chemical weapons shall be under the jurisdiction of the court, should be under the jurisdiction of the court. Because during the ISIS and Syrian conflict, it was found that ISIS acquired chemical weapons from depots in Iraq. And at the same time, the Syrian forces also acquired chemical weapons from some of the Western powers, Western countries. So, although these countries do not have the capability of manufacturing chemical weapons or biological weapons, they are acquiring it from other countries. So the countries that also manufacture and supply should be brought under the jurisdiction of the court. That is very important. If the court has to curb the use of chemical weapons in the future. Thank you.
Thank you,
Very good.
Professor Tripati, for your presentation and sharing us that point of view that indeed is very important that the ICC should, in these cases, have jurisdiction. Also, as you mentioned, on Syria, we need to see and to study how Germany is prosecuting the Syrians who had committed war crimes in that country. And also, it will be very important also for Brian and for us and for our audience to do some research through the criminal statutes of each country, how they regulate, or if not, the use of this kind of weapons within their own legislation. Is very important. Hence, at some point, if I don't know if a country, I don't have to check it, but I'm going to do that research, has in his own criminal statute or criminal code this regulation, like a terrorist attack or something like that related to biological and chemical weapons, under universal jurisdiction, at some point, anyone could be tried in this particular country. For example, if Germany, I don't have checked the German code, the German criminal code, but I'm doing that's an example. For example, if or Spain, that they bound under universal jurisdiction, they can thinking out the box, use now that in Germany under universal jurisdiction is prosecuting two war criminals. Probably they can use universal jurisdiction to go forward in the aspect of chemical weapons against civilians. So I agree with you, Professor, and it's important to share to do this kind of research also for Brian, that he's beginning in the field of the research to check if Germany has in his own. I'm going to check it also if they have in their own legislation something related to the use of chemical and biological weapons. Okay, if that's it for us, I pass the venue to Professor Milton for closing today's debate.
Well, thank you very much, Dr. Marotta. But before I can close, probably Mr. Rampane has something to say, or Professor Dr. Thank you very much, Dr. Marota, for that. But I want to find out if Professor Sripati has something else to add on, or Dr. Rampane.
Thank you.
I know there's always something still left, and I think we shouldn't thwart that. I know we indicated the limit time, but I can see it's not working. Sometimes we need to drain these intellectuals, right? They don't go back with everything. Yeah. Our viewers of
milking them.
Yeah. It is a disservice to allow somebody going back loaded. It's very useful. All these contributions are very brilliant. And when I listen to them, I can listen the whole day. So, Prof, you have anything for us? Just feel free. And remember also there was the issue we said about the ICC, US trying to come up against the prosecutor. If you have anything generally, you can still talk about that. The ICC just 2 days ago banned the ICC prosecutor, I mean the US, with the yes.
I want also to bring something to the desk that maybe we can discuss it in the following weeks, but it has some kind of relations about what we are discussing right now. Is the action of the Netherlands and Canada,
yes,
before the International Court of Justice to go forward the case of the Rohingya trials against yes, because they are being spread and there have been killed like in Asia, and I think probably under this I think it was on Tuesday that they made the communication, the Netherlands and Canada before the International Court of Justice of these Rohingya human rights violations. Probably as they decided to go pro motu after these incidents of human rights. Also, it can happen by other countries to go like this against Syria. That is a case that they're using chemical weapons. So under customary law, it can bring more power for the ICC for taking future decisions in future cases related to crimes against humanity using chemical and biological weapons. That's what I remember. I tried to put on the desk. However, we can the Rohingya case and what is Canada and the Netherlands doing in the International Criminal Court of Justice. We can discuss this in another moment, but I think it have some kind of relation. The two countries that have worked for the human rights around the globe in these past 50 years, they are trying to make a trend to prosecute crimes that sometimes the ICC doesn't have jurisdiction for doing that, or there are some politics behind that. They don't want to use some of that. I mean, that's to doing the devil's advocate premises, but I think we should, in this point, try to mention that countries under the principle of democracy and the prevail of the human race and the human rights of all the people around the globe, under the Universal Declaration of Human Rights, they can, under natural law, positive law, try to make this happen at some point. So let's see what's going on in Germany relating to the prosecution of these Syrians that committed war crimes, and if they can open the window of what we are discussing right now. Okay, Professor. Anyone else wants to add us?
One last statement.
Yeah. Okay.
The prohibition on the use of chemical weapons today recognized as a part of international customary law. It has become a rule of international customary law. So states cannot afford to violate rules of customary law.
Very powerful. Thank you, Professor.
Thank you, Professor.
Mr. Brian, I liked your analysis of the Vienna Convention on Law of Treaties in terms of interpretation. But there's something I want us, you see, I came in, when I brought in that point, it's not that I was contesting the point that you put across. Professor Sripathi and Dr. Marot, I think, will agree that that was very good analysis of Article 32 of the Vienna Convention, the Law of Treaties, with regard to interpretation of statutes. But we also want to, don't lose, what I talked also has connection with Article 31, paragraph 4, which gives emphasis to the fact that the drafting history, the travail, should not be ignored. But I wanted to mention one thing. Even when the drafters, now we are talking about the drafters of the Vienna Convention on the Law of Treaties itself, not of any other text. Even at the time the drafters of the Vienna Convention on the Law of Treaties were working on these provisions, they were not totally unaware of the complications that come along with looking at the history of the drafting of a particular text. They included it, particularly Article 31.4 talks about having recourse to the drafting history, the travail. So they knew that that is very problematic in itself, and we all agree, because how do you establish at the time, because there were arguments that even somebody can put in any mischievous in the process, not necessarily mischievous, but for their own intentions, because people have interests when they come into the table. And should we use such perverted interests to be able to interpret the current statute? No. So there are problems related to, there are a lot of problems related to going into the history. You seem to be going out of network. Are you okay? Brian? You can hear us?
Yes, I can hear you, sir.
Yeah, I can see you have complication.
Yes,
We just wanted to commend you for the good job you're doing, and you should continue doing that as you share with the professors. And I want you to be very keen on what the other professors are presenting as well. There's so much to learn from the experience of Professor Sripathi. You must have noticed that yourself. There's so much that he has garnered, so take advantage of that. I just wanted to reinforce Article 31.4, talking about that. But then why I brought in that, just as I said in retrospect, the 32 itself is not hostile to, as a whole, it's not hostile to the issue of history. It's very critical. But we said, my conclusion was that each case should be handled with its own peculiar characteristics. We should have factual interpretation of a given case and draw a conclusion different from the other depending on what we have obtaining. And we emphasize that with regard to this particular one, Article 8, it seems it's very clear that a lot of attempts were made which are very manifest. It was so serious that if those controversial arguments were to continue, the Rome Statute could have been delayed, maybe it could not have been passed, simply because there would be no agreement or consensus on that issue of nuclear, biological, and chemical weapons. And we've seen that the same thing repeated itself 7 years later, I mean, at the 2010 Kampala Review Conference, that again, that same obstacle, that same argument recurred, and they abandoned it on account of winding up with that conference. Because had they picked it up to its logical conclusion, they would still have had a problem. So it's important also for our viewers to note that much as the convention gives all this, and there are various canons, by the way. It's not just a literal interpretation or looking at the intention of the drafters. The intention of the drafters becomes critical. That's why when we look at Article 6 of the Rome Statute, you would want to talk about the intent and knowledge, you see. So sometimes we glean the intent and knowledge thing because we want to see that whoever is being committed had the intent and knowledge. But then how do we get to that? We also still have to go back. We look, a lot of factors are involved. So I want to commend your contribution. And as usual, Professor Sripathy, that was very powerful. You've introduced the issue of customary international
Thank you.
and a lot of other things.
I want to, can I add something?
Yes, yes. That is why we are trying to motivate you to come up with anything. Go ahead.
All right. Yes. From my submissions, I had argued, it's going to, it looks like there are two schools of thoughts for those who are for the idea that the ICC would have jurisdiction, arguing purposive interpretation, and for those who are arguing against it, arguing the intention of the parties. So arguing for for the argument that the ICC does not have jurisdiction, one may also add the fact that there are a lot of inadequacies in terms of firstly the monitoring and secondly the inspections, because if you can look clearly to the convention before that, which it clearly stated that it had created an organization which was responsible for firstly monitoring, and secondly it was also responsible for inspections. So one may also argue that the inadequacies in the Rome Statute may mean that there was never intention to include those biological and chemical weapons. So it's going to be really two schools of thought clashing, and as you had already stated, I think the one that extrapolates on the intention of the parties at the end of the day.
We seem to have lost you. Okay.
To win the debate.
All right. We seem to be losing you, Mr. Rampani. But that was good. That's a good addition. Prof, do you have anything else to state, Professor Sripathy? Thank you, Mr. Rampani.
Yeah. A parting shot.
Oh, yeah. Let's get that parting shot.
See, when we speak of the jurisdiction of the ICC, the ICC derives its jurisdiction and powers from the statute.
Yeah.
So the statute must be clear as far as its provisions are concerned. Otherwise, the ICC will be in a realm of doubt whether it should exercise jurisdiction or not. For instance, if you take a domestic setup in a country, at least in India, we have the Supreme Court and the High Courts in various states. Now, these courts are known as constitutional courts because they derive their jurisdiction and powers from the Indian Constitution. And the Constitution is very, very clear. So, I expect this kind of clarity in the Rome Statute also, so that the ICC can clearly establish jurisdiction and subsequently exercise that jurisdiction. That is very important, because as we had discussed this whole evening regarding those two provisions, Article 8, 2b, 17 and 18, though the provisions are there in the statute, there is no clarity. There is no clear-cut definition as to what a chemical is and what a chemical weapon is. So these kind of doubts in the provisions of the Rome Statute will put a lot of difficulties on the court while exercising jurisdiction, because the prosecutor also will have a lot of difficulties in convincing the defendant state. While prosecuting the state, he has to be clear in his ideas, saying that these are the crimes that the state has committed and you are guilty of this. So there should be a kind of concreteness in the arguments of the prosecutor, and that is possible only when the provisions of the statute are clear. Otherwise, the prosecutor will always be in doubt, and which is not a good thing for the ICC. This is what I would like to.
Well done, Prof. Just with your parting shot, we still don't want you to go. Let me just ask you one thing. Let me get your view, but also the other panelists will be able to come in if they wish. The question is, if for any reason, one would argue for analysis purposes that if the states who are present during the Rome Statute drafting, negotiation and drafting the 1998, and those subsequently present at the review conference in 2010, did not want the use of chemical or biological weapons to be made criminal, if they intended that that is the position, this for analysis purposes, do you think they would still have, or do you think they would have made sure that not even the use of poisonous asphyxiating be allowed to find its way into the statute? I'm trying to get back to what Professor was saying, which I agreed with really, that the interpretation clause was very critical to, for the avoidance of doubt and to avert any ambiguity in the interpretation or construction of the terms. Do you think the ease with which these terms were allowed into the statute, does it give leeway that possibly there was hope that they should finally want to use biological? What is here really? Why do we have the term poisonous gases and analogous liquids in the statute, while not necessarily, because we know these are actually chemicals and they're biological, some of them are biological. Why would we still have this? If they did not want anything to do with this, why wouldn't they have altogether objected? What is your take on this? What do you think about this? The manner they were using asphyxiating, poisonous, and other gases. What do you think, by extrapolation, would have been their intentions to allow only these and not altogether forget about chemicals? And I'm trying to look at this with a view to seeing the future. Do we even have any success possibilities, chances of success that states would agree to ever introducing anything like nuclear? So what are your views? It's not very clear.
No. As I mentioned earlier, the provisions must be clear. When we speak of chemical weapons, if the provision says that use of chemical weapons shall amount to a war crime, then there should be a clear-cut expansion of what is a chemical weapon, what are the chemicals that go into the weapon, the various chemicals. Now, the two basic chemicals that are used in chemical weapons is sodium fluoride and potassium fluoride. And apart from these two chemicals, there are so many other chemicals that are used for manufacturing chemical weapons. So I would say that the provision should be more clear. There should be a clarity so that the defendant state which makes use of these weapons cannot use the lacunae in the provisions of the statute to escape liability. The provision should be designed in such a manner that the defendant state cannot have any possibility of escaping liability. That is what I want from the provisions of the statute.
Powerful indeed, powerful argument. Back to you, Brian, just before we wind up. Talking about canons of interpretation. Are you with me? Mr. Ramapane? We seem to have lost him now altogether. All right, on that note, Dr. Marotta, do you think there's anything before I wind up now?
No, I think everything of our debate has been met. All the points that we want to discuss.
Yes.
Yes, I'm with you, sir.
Oh, he's in audio. Brian, are you there?
Yes.
No, he's
yes.
yes, he's entering.
Am I audible, sir?
Oh
Yeah,
yeah,
he's in.
but your motion picture is not. Your video is all right. Okay.
Yes, yes.
Yeah. Okay, Mr. Marota, I can get back to him. I was saying,
Yes.
just as a parting shot, you introduced.
Yes. In trying to answer your question, sir.
Oh, you got the question right. Okay, just
Yes, sir.
if you got the question.
Okay. I think it's going to be very, very, very difficult for us to have, or for future to say that the International Criminal Court is going to have jurisdiction over both nuclear, chemical, and biological weapons, looking at the political landscapes. Because if you can go back to 1998, it was a clash between poor and rich countries. Poor countries arguing that because they cannot afford nuclear weapons, now the rich countries would want to argue that they should not be allowed to use whatever they can afford. And the absence of nuclear weapons, prohibition of nuclear weapons in the Rome Statute is always going to be very, very difficult, because it looks like it's a clash between the poor and rich countries.
All right, that is good. But there's another question I put across, probably when you're offline. I just wanted to be sure that you got it. I'm sure that was well answered, and Dr. Sripathi also gave in a very good input. Now, and also there was some input by Dr. Marota, I think, as well. Now, mine was specifically also to you on the issue of the canons of interpretation. In the light of the arguments we put across literal interpretation, we have about 3 major interpretation canons of instruments available to whoever wants to interpret texts. There's the literal interpretation, and there is the issue of looking at the intention of the drafters by going back to you brought in very well your argument on Vienna Convention, Article 32. And I tried to refer you also to look at the emphasis that was laid in Article 31, paragraph 4. And I underscored the fact that there was a challenge. Even at the time they were doing 31.4, they were aware that it would not be easy, to be problematic when we keep on relying on the intention. I just wanted to ask you whether you still have other information about what you want to share with us and the viewers on the issue of other options of interpretation that will be available to the court in respect of this very vexing provision. Looking at the way you very ably you very, very well put across the arguments of 32 Vienna Convention law treaties. Or anything general about interpretation, okay. your views on this one as a participant. Yes.
Okay, thank you very much. The problem that the courts normally have is moving away, because what they will normally use is the literal interpretation. If they are satisfied, then they will close the case. The problem is, at what point do the court move away from the literal interpretation to look into the intention of the statute? So perhaps Prof can shed light on that. And at what point do the court take that detour to say that now we are moving away from the literal interpretation?
Okay, that's a good question. Ordinarily, when we talk of the literal interpretation, it's clear that the plain meaning of the statement would be able to communicate what actually the intention itself is. The plain meaning would bring out any ambiguity, would not be arise. It's unambiguous, and the parties have no contest, unless one is trying to advance a nefarious argument or construction of that particular provision. Then it would have all these other instruments available to it. But essentially, I don't think there's a hard and fast rule that governs how the court would approach a particular interpretation. It depends on who is presiding and what school of thought they hold. Because, We hold different schools of thought. I ascribe to a different school of thought. Professor Sripathi, Doctor, each of us would ascribe to any school of thought. Would even try to engineer our own school of thought by virtue of our standings. As intellectuals, we need to have our own positions most of the time. I take my own analysis, and I always give my own parameter about a situation. So how the court would approach one would depend on that particular presiding officer. Even if it were let's talk about the International Criminal Court at the trial chamber or pre-trial chamber, where this issue would, in my view, would first be litigated very hotly. Each of them, probably if it's presided over by the 3 judges at that point, each of them would have their own view on a particular place. They could concur and dissent on a particular point. So the issue of interpretation would be if, to me, there's no contest at any level and the court itself is satisfied with their own position, that interpretation would lead them to drawing a logical conclusion at the end about the outcome of the case. Then they would take that particular line of interpretation. But as I say, each case would be determined on a fact-to-fact, on a case-to-case basis. All right. I think it would go on and on, but if you have one last thing to say, then we hear it. Just on interpretation, I just want you to talk about interpretation because of the way you approach it in a good manner, right? Anything? If not, then I'll be able to wind up, unless Prof has something else. Yes, Mr. Ampane. Can you hear me?
No, you can wind up, sir.
You have nothing more?
Yes, I can hear you. You can wind up, sir. No,
All right. Okay, Prof. If there's nothing else, I want to thank you all. We are not putting in a corner. You've done very well.
No,
Prof, there's always a.
I would like to.
Yes.
I would like to save it for another day.
Oh, okay. I like that. Thank you, our viewers, wherever you are. It has been awesome. We thank you for being with us this end, and we thank you, panelists, for all that you contributed towards this very vexing topic. And we hope to see you next time. That is all for now, and bye-bye.
Thank you. Bye. Bye.
Bye. Bye.
Right.
Bye.